Hello, my name is Ian Larkins of Radius Law and welcome to our monthly commercial bulletin brought to you in association with LexisNexis. For more information on any of these stories, download our News In document using the link shown on your screen now. In a recent High Court case, an employer's claim against two former employees for stealing confidential information has been reduced from £15 million to just £2. It was proven that the former employees had stolen information. However, after legal letters were issued, the information was returned and it was accepted that it had not been used by the former employees and the employer had not suffered any loss. It's well known that penalty charges are not enforceable under English law. However, recent case law has noted that a charge will only be a penalty where it is extravagant or unconscionable. The recent case of Vivian Westwood v Conduit Street Developments concerned a side letter to a lease which capped the rent at £125,000 per annum. The side letter, however, could be terminated for any trivial breach of a lease, and if it did, the rent would rise to the market rate, £232,000 in this case, going forward and retrospectively. The court said that these factors made it an exorbitant or unconscionable bargain. It was therefore a penalty and unenforceable. In the case of SAP UK v Diageo, Diageo had integrated some of the functionality of SAP software into applications and made them available to its customers and sales staff. SAP's license agreement stated that a license fee must be paid for each user, but did not define user. As a result, the court decided it must have its obvious meaning and that in this case all such customers and sales staff would need a license, albeit that they would not need a full premium license. In recent weeks, we've seen a flurry of Court of Appeal decisions providing more clarity on the requirements for responding to subject access requests. These are requests for personal data under the Data Protection Act. The summary of these cases is the exemption for legal privilege only applies to English law legal privilege. There must be a thorough investigation before refusing on the ground of disproportionate effort, and blanket refusals to comply are not acceptable, but the requirement does not extend to leaving no stone unturned. Stricter rules on obtaining consent before processing personal data is one of the cornerstones of the new GDPR. This is causing significant concerns for businesses as they work to adapt their systems to be compliant. The ICO has published draft guidance to help with this task. The Committee on Advertising Practice has issued guidance on affiliate marketing. Affiliate marketing is performance-based marketing where an affiliate places ads or links that direct consumers to a company website. In short, the same normal advertising rules apply, particularly the requirement to ensure that the consumer is aware that it is an advert. The European Court of Justice has provided guidance on two Muslim headscarf cases. Any ban on wearing a headscarf or other religious symbol must be a general occupational requirement of the employer, not the subjective view of an employer's client. It must follow a neutrality dress code policy and be justified and proportionate. The court thought that an employer's policy of religious neutrality can be justified, but that proportionality will be more difficult to show. Employers need to consider each role and whether an employee can be moved to an alternative role before leaping to a dismissal. The case of Fidessa plc v Lancaster has provided useful guidance for employers considering flexible working requests. In this case, Ms Lancaster was made redundant after refusing to accept an alternative role. Ms Lancaster, a mother, had refused the role as it did not allow her to continue her existing flexible working arrangements. The tribunal agreed that she had been subject to sex discrimination, as women are more likely to need flexible working arrangements. The employer should have considered whether the new role could be offered honouring existing flexible working commitments. We reported on the Locke v British Gas case last November after the Court of Appeal hearing. The decision considered whether average commission should be paid in holiday periods, but offered little clarity for future cases. An application for appeal to the Supreme Court has been refused, so we are now stuck with the Court of Appeal decision. The Consumer Rights Act is less than 2 years old, but the government now intends to issue a green paper to introduce new consumer protection measures. These include more rights for enforcement bodies seeking fines against businesses that mislead or mistreat customers, new protections to stop unexpected payments when a subscription is renewed or when a free trial ends, and proposals to make consumer terms and conditions clearer, shorter and simpler. The CMA has launched a new campaign, Cracking Down on Cartels, to raise the awareness of the £100,000 rewards that are available for reporting cartels. In addition, the European Commission has launched a new tool to allow individuals to anonymously alert the Commission about anti-competitive practices. These measures raise the importance of competition law compliance and internal whistleblower systems. It's worth remembering that if a company is the first to report a malpractice, then it can get immunity from fines. A report directly to the Commission or the CMA by a current or former employee will not provide the company with immunity. Thank you for tuning in to this month's Commercial Bulletin. We'll be back in May with more of the month's key legal updates.